Proportional right to an inheritance of married persons. Often you would like to give someone a treat, to give thanks to someone, or to pay forward. Due to the revised Swiss inheritance law, you will always be able to freely dispose of at least half of your estate from January 1st, 2023 on. It's worth considering whether the statutory regulation suits you or whether you would like to deviate from it, for instance, by making a holographic will. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich, Switzerland. If you enjoyed this video, please like it and forward it to someone else. Swiss law determines who will inherit from you and how much if you die intestate, respectively if you remain inactive. How much your legal heirs, so your blood relatives and or your surviving spouse, will receive depends on your family circumstances. In the case of surviving spouses or registered partners, the Swiss Civil Code determines the legal share of the inheritance. If you leave children, your spouse and your issue each inherit 1/2 of the estate. If you are issueless, your spouse inherits 3/4 and your parent 1/4 of the estate. Should one parent be predeceased, his or her children take his or her place. It boils down to the following. Your spouse inherits 3/4, one parent inherits 1/8, and your sibling inherit 1/8. Should both of your parents be predeceased, your spouse inherits 3/4 and your siblings 1/4. Do you agree with this legal regulation, or would you like to deviate from this? Please ask yourself, whom do you leave behind? Issue as well as surviving spouse or registered partner are entitled to a compulsory share. The statutory entitlement is 1/2 of the statutory succession rights. You are free to dispose of that part of your property which exceeds the statutory entitlement of your issue or surviving spouse. As of January 1st, 2023, a testator may always freely dispose of at least half of his estate. This has various practical implications. You can make sure that your legal heirs only receive their statutory share and dispose of the available quota, for instance by naming heirs to a fraction of the estate or by bequeathing a legacy to a beneficiary. You may consider treating your descendants unequally, however, you really need to state a good reason for this. Or you may support a good cause or outside third parties, such as life partners or stepchildren. The latter are not obliged. The latter do not have any right to inherit you, and you are not obliged to do so. However, if you do, please clarify the inheritance and gift taxes. You are free to decide what you want to leave behind, whom you want to thank, and whom you want to support. You really have the opportunity to do so. Please put pen to paper. Do you have any questions? I look forward to supporting you fulfilling your personal and last wishes and to have a peaceful distribution of your assets. Please contact me for a personal consultation.